Okay, it is live.
Okay, yeah, it says it in the corner now.
Okay, yeah, there we go. Okay, so we'll go ahead and just restate that for the record. My name is Matthew Vitale. I'm an Associate Justice with the Judicial Board presiding over this case. I am the one justice in attendance presiding over this case, pursuant to the fact that the other two justices on the board are unfortunately involved in this trial. Kevin, if you could go ahead and reintroduce yourself as the clerk.
This is Kevin Brown, clerk for the Judicial Board. I'll be taking this.
Okay. We also will go ahead and let me just pull up a summary of the charges. I'll go ahead and read that just from our minutes. Maybe one moment. Excuse me. Just one moment, please. Okay, so scroll through this real quick, one moment. Right, so it's a petition for violation of the CCR bylaws, again, Article 10, Section 2, subsection G, pertaining to what is colloquially known as doxing. So that was the charges, so we'll go ahead and go through. Okay, so with that being said, let me go ahead and get a timer started. We'll start with the plaintiff's case in chief. The plaintiff will have 10 minutes to present an opening statement. What's that?
Thank you.
Both had pled not guilty. One moment, Kimo. We'll just let the clerk catch up. Go ahead, Kim.
Your Honor, an organization must have order. Indeed, it is the function and purpose of our organization to, I quote, promote good government at all levels, end quote. Ethical conduct is not an easy matter to approach. However, our basic understanding of the rule of law, our society requires it. To quote our parliamentary authority, a society retains the right to, quote, require all of its members refrain from conduct injurious to the organization or its purposes. No one should be allowed to remain a member if his retention will do this type of harm. That's Robert's Rules, page 643, lines 8 through 11. It is therefore the prerogative of this board to maintain order in our society by enforcing the rules as democratically agreed. And indeed, this rule is not vague. Article 10, Section 2G of the bylaws explicitly prohibits the, quote, unauthorized public disclosure of personal communications, end quote. In my petition, I go over the exact legal clarifications and what constitutes what. But it's important for both you, the Honor, and for the society to recognize this resolution did not exist in a vacuum. It was not just arbitrarily imposed as some sort of pedantic error on behalf of the defense. In fact, in the resolution on the floor, Representative Zeiner of the Central Coast wrote explicitly that the intent of this resolution was in response to, quote, damaging individuals' reputations, end quote, as well as, quote, presenting problems for the effectiveness and cohesion of the organization, end quote. Zeiner further contended that doxing has, quote, harm the reputation and productivity of the California College Republicans and its members' personal and professional lives. The intent of this legislation is clear. We have a plague wherein our personal conversations, often jokes, are manipulated and turned into media scandals as basically what become interpersonal political weapons. The weaponization of the personal, along with the decline of traditional values and the proliferation of unfettered media access, has forced the organization to take action, as the board of directors did. Today, I intend to prove two simple facts. First, the defendants violated the Ethics Code, Article 10, Section 2G of the CCR bylaws by leaking an undisclosed document, or unauthorized document. Second, the defendants tangibly harmed the plaintiff, including both the cohesion of the organization through the facilitation of leaked documents and her personal reputation. And already, Honorable Justice, I have already submitted compelling empirical evidence to substantiate those claims that have been made. I've shown not only through providing you screenshots, but through the defense's own petitions to you, which implicitly acknowledge that they did indeed violate the statutes in question, prove my case. The plaintiff therefore urges his honor to convict the defense of a violation of Article 10, Section 2G, and correspondingly to take away their good standing. Thank you, Your Honor. I rest.
Okay, thanks for that, Kimo. Go ahead and
At this
you've already.
Sorry.
Go ahead, Kimo.
At this time, I'd call upon my first witness, Ariana Rowlands.
Okay, let's go ahead and get Ariana back on here.
Hi.
There she is. Very good.
Ms. Rowlands.
And just one moment. So just as a reminder, Ariana, you have 3 minutes for your testimony. Kimo is going to be asking you questions, and we are going to go ahead and go from there.
Your Honor, could you swear in the witness?
Yes, I'll go ahead and do that. Ariana, you can repeat after me. I do solemnly swear or affirm
I do solemnly swear or affirm
that the testimony I am about to give
that the testimony I have to give
will be the truth and nothing but the truth.
will be the truth and nothing but the truth.
So help me God.
So help me God.
Okay. That being out of the way, Kimo, you have 3 minutes to question your witness, and those 3 minutes will start now.
Ms. Rowlands, what was your relationships to Miss Marks Noble?
She was my friend and my staffer as the membership director of the California College Republicans.
What were the duties of Miss Marks Noble?
She would maintain membership lists and think of ideas to help recruit more members to the California College Republicans, but also assist in tasks that I would ask her to do and help me out with other staff.
What were your normal conversations about staffers?
Usually we would talk about stuff that was going on in regards to the California College Republicans. That was what most of our conversations revolved around.
What was your reaction upon the leak?
I was kind of shocked. I was actually very shocked because I did not authorize it, and it seemed as if it was totally irrelevant and just put out there to try and harm my relationship with another one of my staffers, the Northern Vice Chair, Ms. Morcott, and to cause division among the board members.
Thank you, Ms. Rowlands. At this time, the plaintiff would yield.
Okay, so you have 1 minute and 34 seconds. What we'll go ahead and do with that time, both Madison and Sarah are going to have an opportunity to cross-examine Ariana, and you, Kimo, will go ahead and have that 1 minute and 34 seconds as a time for redirect examination.
Thank you.
So give me 1 moment. Let me just write that down really quick because I'm going to time the rest of these. I just want to make sure I don't lose track of that time.
In the meantime, Ari, could you try to get closer to the microphone? It's kind of hard to hear you.
Yeah. Sorry, guys. This is my face.
Okay, so again, just for the record, Chemo, you've got 1 minute and 34 seconds of questioning for Ariana after the cross-examinations proceed. Just as a quick procedural note, so Sarah, you've designated Maddie as your representative. Are you going to be yielding your right to questioning to Madison, or are you going to be asking questions yourself?
No, I'll yield my questioning time to Madison.
Okay, so in that case, Madison, you will just have your 3 minutes to ask your questions, and we will go from there in that case. So, Kevin, are you caught up? Okay, so in that case, Madison, your 3 minutes will start now.
All right. Ariana, is it true that Sarah Morcott was actually an elected official of CCR?
Yes.
So that would mean she is not a staffer, correct?
She is part of the staff of the board, yeah.
Staffers are defined as members who are appointed by the chair. So Sarah Morcott wasn't appointed, correct?
She was not.
What Rule 401? What is the relevancy of this line of questions?
I'm just going to prove that Sarah does not serve as at the pleasure of the chairwoman according to the CCR Constitution, and she serves at the pleasure of her region.
Objection, Your Honor. Rule 401. That doesn't bear any relevancy to the case. Nowhere in the statute does it ask that you must be a staffer to violate it, only that you must be a member of the board of directors.
Yes, but I'm trying. What I'm trying to get across is that as far as staffers go with personal relationships, she can't be held accountable for personal relationships to the chairwoman when she's actually more held accountable to her constituency.
But objection, that's not what the code says.
Okay, so Madison, correct me if I'm wrong. Your argument is that because Sarah is a staffer,
Not a staffer.
not a staffer, excuse me, that she can't be held liable by this section of the bylaws?
It's just going to prove my argument that I'll state in my opening statement when I get that chance. I'm going to prove that there was no professional or personal relationship that was affected.
Okay, I view that argument as legitimate, and I'll yield.
Yeah, we'll see where it goes. Go ahead.
And
Oh, 1 second. Let me restart time. So you're at 2:33 for the record.
all right. My time.
That's it?
Nothing further.
Okay. Okay, that's fine. Chemo, do you have any further questions for Ariana?
No.
Okay, so Ariana, you're free to go. Thanks very much for being here, and have a good rest of your break, or good rest of your day. You're not in school, so you're just continually on break.
Right.
Bye. Okay, so that being taken care of, the plaintiff can move on to his next witness if he has one.
Yes. So that's myself. So I guess I need to be sworn in, and during this time, my representative, Mr. Paniotis Frusiakis, will ask me questions.
Yep. Understood. So I'll go ahead and swear you in, Chemo. Just repeat after me. I,
Chemo Gandall,
do solemnly swear or affirm
do solemnly swear or affirm
that the testimony I am about to give
that the testimony I'm about to give
is the truth and nothing but the truth.
is the truth and nothing but the truth.
So help me God.
So help me God.
All right, thanks. Pawn, you can go ahead and get started. You'll have 3 minutes starting from right now.
All right, thank you, Your Honor. So, Mr. Gandall, what was the context of your discussion with the defendant, Ms. Morcott?
At the time, we were simply talking about CCR, as many people normatively engage in conversation. I would say that I was asking her what her specific concerns were, but at no point was I asking a specific contention about a screenshot or anything like that. That was sent later, and that had to do with a personal staffer issue. So it seemed like the context of the discussion was simply, about CCR in general.
All right. And then also, what did Ms. Morcott send you?
I was sent a screenshot sent to her by Miss Madison Noble Marks that stipulated her calling Miss Rowlands issuing a verbiage to Miss Morcott, and it was a personal staffer issue, it seemed like. So it seemed as if a confidential staffer issue had been taken out of context and then given to Miss Morcott in an attempt to damage the ability of the chair's Human Resources Department.
All right. Thank you, Your Honor. That ends this particular line of questioning.
Okay, so you're at 145 then. So after cross-examination, Pon, you'll have 1:45 to ask questions of Chemo. And I guess since again Madison is Sarah's representative, Madison, you can go ahead and begin your 3 minutes of questioning for Chemo whenever you'd like. All
right. Is it true, Chemo, that you were involved in a personal relationship with one of the defendants, Sarah Morcott, the Northern Regional Vice Chair?
I had a personal relationship with her at a prior time, yes.
And is it true also that at some point you said that you would not implicate her for the screenshots that were sent during that conversation?
I would say first off, that's not relevant to the conversation. Second off, I would say what that was actually in relation to had to be contextually with the fact that I was not going to go about slandering Miss Morcott. If you recall, we had discussed prior on the phone that we would be courteous to each other, which was clearly not the case, but is totally irrelevant to the trial. It has nothing to do with the case, the violation that occurred at hand. It was simply a colloquial device, as I stipulated in my petition to His Honor, about acting responsibly, which is clearly not something that Miss Morcott intended to take upon herself.
But in your opening statement, you argued that the defense is utilizing this trial and allegedly leaked this screenshot for political purposes and wielding it as a political weapon.
Yes, that is what I stated.
And you're the chair of Champion CCR as it stands, correct?
Honor, objection. This is starting to spiral out of relevancy here.
Okay, Madison, response.
I'm just trying to connect the fact that he is
beginning to get
the chairman. He was involved politically with a campaign that is happening, and obviously Sarah Morcott is on the opposite side of that campaign. So I'm just prove that this is a political weapon when he's trying.
But this is wholly irrelevant to the charge at hand. The charge at hand has nothing to do with my character. The charge at hand has to do with the fact that there was an undisclosed document released. It has nothing to do with whether I intended it to be released or anything of that sort. So this
honestly, Madison, I see where you're trying to go with this. I don't think there's nothing in the statute that says that you're only liable if you're trying to use it as a political weapon, or you're not liable if you're trying to use it as a political weapon. I see where you're trying to go with this. I don't think it's the right direction for you to go, so I'm going to go ahead and ask that you move on.
And if I will answer that question in part, though, for the defense, as I will.
Sure. Just let me know when you're going to start. I'll restart the timer.
I'm starting. So I agreed with Miss Morcott over call because we wanted to talk to this person on person, because that's what we do in good personal relationships, that we would act courteously, and that's not what happened, which is why this ended up going the way it did, because there was irresponsibility taken. As I showed in my opening, there had to be a harm, and that harm emerged out of the defense's actions. Had the defense acted responsibly, there wouldn't have been a harm.
Okay, next line of questioning, Madison.
I yield my time. Nothing further.
Okay, so in that case, Kima, do you have any other witnesses to call?
The plaintiff would rest at this time.
Okay. Yeah, and Pon, you didn't have any other questions to ask Kimo, did you?
No.
Okay, so that strikes off that time. So Kimo, are you resting your case in chief as a whole?
Yes, Your Honor.
Okay. So in that case, okay, so Madison, you and Sarah have an option. So you guys, so obviously again, Madison, you're Sarah's representative. If you'd like, you can just go ahead and conduct both of your case in chiefs as one. And Madison, you can just call all the witnesses, do everything, or if you'd like, you can separate it. If you guys have any separate arguments that you'd like to do.
I think Sarah has housekeeping matters before I start my opening.
Okay, go ahead, Sarah. 1 second, actually. I think you might be muted. Let me check something.
You could ask for a recess.
Give me.
You could ask for a recess.
No, I don't think we need a recess. Sarah, can you just say something?
My mic was muted.
Okay, that's fine. So Sarah, what did you need to take care of?
So a couple things. So first, it is eminently apparent, although the plaintiff seems to deny it, that this is a politically motivated case. And I would ask for the recusal of the current justice, considering that it is clear through social media that you are in support of the plaintiff.
Okay, so I'm going to go ahead and point you to I think it's in the charter, exactly where we define conflicts of interest. Right. So Judicial Board Charter Article 7, Section 5. A conflict of interest for justice shall only pertain to the following cases. A family member is significantly involved in a case. B, a spouse or ex-spouse is significantly involved in a case. C, the justice is pursuing an intimate relationship with a significant member found within the case, or has sexually fraternized with a significant member found within the case at least 1 year prior to the filing of the case without public disclosure. D, the justice has pursued open, notorious, and numerous personal attacks against either the plaintiff or the defendant in any case. So I'm going to go ahead and address this. Whether I like or react to a slate's social media post doesn't satisfy any of these conflicts of interest. I have neither a family member, a spouse, ex-spouse, or ex-girlfriend or boyfriend involved in this case. And neither have I pursued any sort of open, notorious, or numerous personal attacks against either plaintiff or defendant in this case. Seeing as that is where we define the conflict of interest, and that has been approved by the executive board, that's what I'm going to hold myself to. And as a result, that's what we're going to go ahead and rest with.
Okay. Second, I suppose I would move for the dismissal of this case with prejudice for the following reasons. First, because the underlying stature that I currently am accused of being in violation of is overly broad. Second, there is no appeals process for this case. This is the only board that I may face. And also the constitutionality of the amendment is questionable under the First Amendment of the United States Constitution.
Okay, so that's a little bit of a different notion. So there's a couple things at play there. First off, your motion is denied, and I'll give you a reason, and I'll give you reasonings why. So as to the notion that, so I'm just going to go backwards since that's what I remember you saying. So as to the notion that it's unconstitutional based on the First Amendment, that's just not the case. When you enter a society, you surrender your rights to the society as to what you put yourself under. We are governed by Robert's rules, we're governed by the Constitution, and we're governed by the bylaws. The bylaws amendment was passed democratically at the board of directors, and if I'm not mistaken, you and Maddie both voted for it. So the notion that you are not held accountable to that bylaw because it is somehow unconstitutional is just false. So we're going to go ahead and move on from that. Anything else?
Yeah. So I also kind of object to the way in which this trial is being set up. According to the J-Board Charter, the trial must be held in person. It's according to Rule 2.1.1. And
as I've said numerous times, the governing authority of the California College of Republicans is Robert's Rules of Order. I have pointed you both to the citation in Robert's Rules. A meeting can be considered in person as long as there is provision for simultaneous oral and audio communication between all parties. That is precisely what we have provided for in this. I can see you, you can see me, and we can all talk to each other. That's the definition of simultaneous oral communication. So given that this meeting is very clearly in person, and frankly, I gave you guys the option. Again, I said you can either have it in person, and if everybody in one room that I decide, or we can have it online. I gave it, so you guys chose in person to start with, and then went on and, if you'll excuse the phrase, bitched and moaned all over Facebook about how you couldn't make it to a trial. Frankly, that's not my problem. If you have something to do, you have something to do, and that means that you need to make it. If you guys should have all read Steinwender, there's an implication of compliance with every sort of order that we issue. So that means that if I designated at the Corona Public Library, you go to the Corona Public Library, or you give me a reason as to why you can't. And again, that's what I did. And granted, the travel is hard, and I understand the travel is hard. And so that's why I said, you know what, instead, we're going to go ahead and do this online. So that way people don't have to travel. That way everybody can show up, everybody can be present, and everybody can be heard. And that's the way things are standing right now. Anything else? Is that a no? Okay, you're muted, but I'm going to take that as a no. Okay, sounds good. Anything else?
I was wondering, since I just presided over a preliminary hearing Sunday, why weren't we allowed to yield our 20 days?
That is something that I was not aware of, frankly. When we look at the procedures, there's a specific time limit.
Yes, Your Honor. So it does seem like there was written into the code that it could be within the time period we mentioned at the prior preliminary trial, and the one the other day, the right to the 20 days was kind of just an informal agreement, not a codified one.
Okay, then that's your reasoning.
The reason is it seems like the judicial rules are very long, and it's the most specific rules over the initial parliamentary rule. The rule discussed at the last preliminary trial was really not a specific judiciary rule. It was a Roberts rule, which was superseded by a judiciary rule. And I think that's found under the judiciary docket and then the hearing procedures.
Yeah, I'm in the hearing procedures.
Yeah, so it's 1.6.2.
Let's take a look at that.
In setting time and dates for formal hearings, the judicial board should allow at least 5 days, but no more than one academic quarter.
Yeah, and so that's what I was working based off of this whole thing. You guys had at least 5 days, and the request to hold this at CCR was significantly more than one academic quarter away from the date of the preliminary hearing. So that's why we arrived at this date.
All right.
I think another reason as to why we tried to get it so early for, what is it again? Gates v. Martin and Marciakis. That case is because of the significant number of witnesses. Frankly, the longer we go into Thanksgiving or into the Christmas break, excuse me, the more difficult it's going to be to actually access those people. So there's also anything else before we proceed?
Nope, I'm ready for opening statement.
Okay, so you'll have 10 minutes, and that starts now.
So it's finals week, and Sarah and I are both at school while the rest of the people involved here have been done for a while. Going in wildly unprepared because our grades are more important than some bullshit trial. The whole reason we're here is because the plaintiff got broken up with and is enacting revenge because he is threatened by Sarah Morcott and me, Madison Marks Noble, for running for CCR state office. The case at hand is more of a question of a violation of a bylaw. The case at hand is more than a question of violation of a bylaw amendment, but a violation of the very spirit of CCR itself. This trial is simply a political tool to remove two good people and chapters from the organization, disenfranchising us and our members and hoping that they get elected.
Objection. This is a ton of personal prejudice under Rule 403, which was very clearly adjudicated by you in a earlier ruling that was wholly irrelevant. So if we're just going to violate prior rulings and utilize the opening statement as a political tool rather than talking about the actual case, then we're distracting from the charter and running afoul with Rule 403.
I'll complete this within my time. There won't be any waits.
I'm not, wait, okay, so the issue isn't whether you're gonna go over your 10 minutes, Madison. I'll cut you off at 10 minutes if you keep going for 10 minutes. So that's not an issue. The issue is that you got to keep things germane as to what the issue is here. The bylaws, the bylaw amendment that we're looking at here, if I can pull it up, the exact text. Okay, that's going to take me a couple minutes, but the bylaws amendment that we're looking at here doesn't have any sort of implication as to whether or not you're a shitty person. So please do keep it germane, keep it specifically relating to the substance of the bylaws amendment as to whether or not you and your client violated that bylaws amendment. Please don't make this personal because it's not personal. Go ahead and continue.
All right. So essentially, what I will prove is that the screenshot in question did in fact not damage any personal or professional relationship according to the bylaws. There was no damage to the chairwoman's reputation done by either Sarah or myself, nor was it sent to a group, quote unquote, encompassing an expansive audience. The only people that have seen the screenshot at the time were the plaintiff, Sarah Morcott, Ariana Rollins, and myself, and now it has been, everyone at this court has seen it because now it's under evidence. So at the time, not encompassing an expansive audience. And as Republicans, we are strict constructionists, and I hope that the court would agree with that philosophy and reach a verdict of not guilty. Thank you.
Okay, thank you very much. And with that, whenever you're ready, you can call your first witness.
I call Sarah Morcott to the stand.
Okay, give me just a moment. You'll have 3 minutes. Go ahead.
All right. So Sarah, can you state your name and any positions you hold in CCR for the court?
Okay, so my name is Sarah Morcott. I'm the president of Chico State College Republicans, and I am the current Northern Regional Vice Chair.
And how do you know the plaintiff?
I had a relationship with him from April until I believe July of this year. We remained on good terms prior to ending our relationship, and until recently we've had a relatively strong relationship.
And so what month was it, did you say, that you ended your relationship with the plaintiff?
I believe that it was July.
And what month was BOD, where we passed this bylaw amendment?
August.
And when did the plaintiff see the screenshot at first?
Objection on the original line of questioning. The question of personal relationships is wholly irrelevant, as we already ruled in this case.
I'm just asking when the plaintiff saw the screenshot.
Okay.
September.
So September. So it was 2 months after.
So it was several months ago. Yes.
All right. And yeah, what did the plaintiff tell you in reference to the screenshot?
He said that basically, like, he told me that he would not use that particular violation against me because it was in a personal context and I was seeking advice. And so.
Objection. First off, Your Honor, under Rule both 401 and 403, it's wholly irrelevant to go into grounds like these. These procedural objections should have been made earlier, but they clearly weren't. And the ones that were, you already ruled upon. It's not relevant to the statute at hand. They're arguing something that has to do with whether I engaged in like a contractual obligation, which was something they should have made.
Okay, what's your response to that, Madison?
I'll move on.
Okay. Go ahead and resume.
And how long have you known Ariana Rollins, the chairwoman of CCR?
I think since February of 2017.
And what was your initial impression of the chairwoman? And her
like the first time.
I'm going to stop you there. I'm going to stop you right there because that doesn't have any, like, I'm going to stop you there because that has no bearing on this case. The case is about Chemo, Sarah, and Maddie, and a screenshot that was exchanged. we already have the substance of what's in the screenshot. We don't need a further explanation of that. So I'm going to go ahead and ask you to move on.
Well, basically what I'm asking is, because the screenshot involves one of the bylaw, for the bylaw amendment, one of the points is it had to have damaged a personal and or professional relationship. And I'm just trying to establish a relationship between the chairwoman and Sarah Morcott.
Okay. That's not something that I saw. In that case, go ahead and continue.
All right. So what has been your impression of the chairwoman and your personal relationship with her?
So I've known her virtually, like on the internet, since February, and we met for the first time at CCR in April of this year. And my general impression, well, I only met her once, so I would say that I viewed her as being a solid professional, but not necessarily like a super close friend. And yeah, that's about it.
And during your time as serving on the board, would you say that you agreed with everything the chairwoman, all of her actions during that time?
Not always. Initially, yes, and then later on, not as much.
Can you name a specific instance?
I disagreed with her with the UCSD case, but I can't name any other specific objections related to state board.
All right, that's it. You're done. Okay, in that case, Kimo, you can go ahead and start your questioning of Sarah. You'll have 3 minutes starting now.
Ms. Morcott, in relation to the screenshot, did you state, quote, "how dare she," end quote?
Yes.
Ms. Morcott, in relation to the screenshot, did you state, "I can't forget that"? Forgive, sorry.
Yes.
Ms. Morcott, would you say that being unable to forgive someone constitutes a change in relationship?
Yes.
Thank you. The plaintiff rests.
Okay. Yeah, and so we'll go ahead and move on. Madison, you can call your next witness, seeing as all the time elapsed for your redirect. So,
can Sarah represent me to call me up?
yeah, that's fine.
May I?
So, all right, Sarah, you'll have 3 minutes starting now.
Okay. So
Did I take an oath first?
What's that?
Do I need to take an oath?
Right, excuse me. Madison, you can go ahead and repeat after me. I state your name.
I, Madison Marks Noble,
You solemnly swear or affirm
do solemnly swear or affirm
that the testimony I am about to give today
that the testimony I'm about to give today
will be the truth and nothing but the truth.
will be the truth and nothing but the truth.
So help me God.
So help me God.
Okay. In that case, Sarah, whenever you're ready, you can proceed.
Okay. So Madison, first, when you sent me that screenshot, did I ask for it from you specifically?
Yes.
And did you warn me at all about not sharing that specific screenshot?
Yes, I did warn you that according to the bylaw amendment, that if that screenshot got out, then we could allegedly be charged for violation.
And is it true, or were you aware of any prior strained relationship between myself and the chairwoman prior to that being shared?
Prior to the screenshot and knowing that, I've talked with you on numerous occasions, and it seemed that you seemed to maintain a professional relationship with Ariana, but on a personal level, it wasn't like a friendly type of relationship.
And prior to me receiving or having knowledge of that conversation between yourself and the chairwoman?
What?
Was that prior to receiving that screenshot or afterward?
Yes, it was prior. The screenshot was dated sometime in July, and the UCSD trial, I remember we would talk about it a lot. you expressed your concerns with your relationship with the chairwoman for quite some time, and I didn't see any kind of change from then. And then when I sent you the screenshot.
Okay, that's all the questions I have. Thank you.
Okay, so you'll have 1 minute and 14 seconds.
Excellent. I'll begin my line of questioning now.
Oh, one moment. Go ahead, Kima.
Ms. Marks Noble, so did you concede in your testimony that you knew what you were leaking was illegal?
I mean, at the time,
Yes, or is that what you told the other defendant, Ms. Morcott?
yes,
So you acknowledged it was illegal, just to clarify.
I acknowledge that it could have been illegal depending on how this case went.
So specifically, you acknowledged that there was a damage.
There could have been, but
So
I
why would you warn somebody if there wasn't a damage?
I just didn't want Sarah to get in trouble.
Understood. Leaking things is often not legal. At this time, the plaintiff would rest.
Okay. Sarah, do you have any further questions for Maddie?
No.
Okay. Maddie, do you or Sarah have any further witnesses to call?
I'll call. Can I recall Sarah?
No, because you ran out of time for redirect, unfortunately.
Okay. Then I guess I rest.
Okay. In that case, you both will have 5 minutes for any final comments, essentially a closing statement. Again, please keep things germane to the the substance of the bylaws amendment. Please don't make things personal. We'll start with the plaintiff. Kimo, you'll have 5 minutes to make your statement, beginning whenever you'd like to begin.
Yes. As I said at the beginning of this entire ordeal, this is a question of order. And there's two simple facts that I showed you. And by the way, the defense basically indicted themselves of, which was they leaked something and they caused the damage. Let me give you this simple. I explained in my petition that relevant damages that can potentially damage a relationship to individuals directly involved meet the standard. More specifically, Black Law's Dictionary stated that a diminution in any manner or degree of the esteem, goodwill, or confidence that people place in a person, firm, or company constitutes a damage. I asked in cross-examination 2 simple questions to Ms. Morcott. First, did she state, quote, "How dare she?" And second, did she state, "I can't forgive that"? She agreed to both of those, that she stipulated those, and then she also agreed it caused a change in relationships, which constitutes a damage under the standard. And literally, the defense concedes in Ms. Marks Noble's own testimony that she knew what she was doing was illegal. This, justice, I ask you, has an important, compelling public interest. We see it in the Trump administration. Leaks have plagued the party, his administration, over really, really stupid things. Somebody's getting fired, interpersonal drama, but the problem is this significantly damages the political capital of the Trump administration because people think it's on fire. There will always be drama in the executive board. But the reason this passed was because Representative Zeiner understood the compelling problem to destroying cohesion of the organization, as he himself wrote. And he further wrote, which by the way was agreed to by the board of directors, that doxing has, quote, harmed the reputation and productivity of the California College Republicans. Not only that, it's damaged personal and professional lives. It's damaged careers. And this was acknowledged by both sides. Finally, I would object to stipulations, basically the only defense made by the opposition. First off, this has nothing to do with personal staffing. The only reason I even talked about that was because it was contextual, but it's not relevant to the case. Allow me once again, Your Honor, to read you the statute. The unauthorized public disclosure of personal communications, either in a group chat or in 101 electronic communications on social media, are illegal. I would also remind this board that to remain in good standing, all members and associate members of the board of directors must maintain an ethical character. This simply has not occurred. Defense Morcott has made an argument that this is unconstitutional. Clearly, as you already ruled, private societies can always regulate. We're the Republican Party. We're not a public agency. On top of that, it was simply factually untrue by the defense they can't appeal. The Constitution gives an appeal process they can go through. And finally, we made every good piece of due diligence to provide an equitable opportunity to be here, as both of them have given. And as displayed by both Appendix A and B of the petition I've submitted, the defense openly argued she did not wish to currently associate with the chairman based on interpersonal staffing issues. Therefore, relationship being broken met the necessary criteria of the standard at hand. I simply ask you, Your Honor, to enforce the most basic premise of our society: law and order. If we can't do that, then the bylaws, the ethics codes have no meaning. Let's keep the law, let's keep the order, let's indict the defense and issue a guilty verdict. Thank you. The plaintiff will rest.
Okay, so you'll have 1 minute and 10 seconds of rebuttal time, just so you know.
Okay, were you referring to myself or Mark Noble?
So no, that was for chemo. So everybody's going to have, I'm going to give you the remainder of your time. So you've got 5 minutes of a statement. Whatever time you have left over after that, you're going to have time at the end to just make one last final comment. Madison and Sarah. So again, we've got the situation where Madison is your representative, Sarah. Do you want to yield your speaking time to Madison, or Sarah, would you like to say something on your own as well?
You divided that 5 minutes into 2.5 and 2.5. You said we have 5 minutes for closing, or how much time?
So each party has 5 minutes for closing. What I'm saying is that Madison, since you are Sarah's representative, if you like, Sarah can just let you speak for her, or both of you can have your 5 minutes. It's up to you.
I would like to have my 5 minutes in this instance.
Okay, that's fine. Then everybody will have their 5 minutes. You guys can flip a coin for who wants to go first. I don't mind.
I mean, I can go first.
All right, Sarah, go ahead and start. You'll have 5 minutes.
Well, the plaintiff is arguing that receiving that screenshot itself and Ms. Marks Noble disclosing that screenshot to me damaged the relationship between myself and the chairwoman. That relationship was already damaged, and that screenshot that I received was merely confirming suspicions that I already held myself, so it did not change the relationship at all. I would also like to clarify that I'm still willing to maintain a professional relationship with Ms. Rollins, simply not a personal one. And that's all I have to say.
Okay, in that case, you'll have minutes and 20 seconds. And Madison, you can go ahead and begin whenever you'd like.
So essentially all I want to say is I'm confirming in the testimony, obviously, there was no damage of relationship here. I don't even see a damage of CCR in general. It seems that most people who have heard about the screenshot, they're not surprised. No one's surprised about it. I don't think it caused any kind of personal, professional damage, and no damage to the organization as a whole. As far as indicting myself, I'm always afraid of anything in the Constitution or the bylaws being used and twisted against me, because that's, Hemo's Ronar master, so we never know what's going to happen. Essentially, like I said before, the only people that have seen the screenshot, which the bylaw says it must be leaked to an expansive audience or a group that encompasses such, and I wouldn't consider the plaintiff, Ms. Rollins, myself, and Sarah Morcott to be considered an expansive audience. So that's about it. That's all I got. And I just said, don't find us guilty, because we have more to give to this organization.
Okay, so you'll have 3:52 minutes in. Chemo, do you have anything else to say that you'd like to use your minute and 10 seconds for?
Yes.
Okay, go ahead. Let me go ahead and mark that up. Minute and 10. Whenever you're ready.
Okay. One sec. Pulling up my. All right. So first off, the relationship, the claim that the relationship was already damaged is not relevant to the case. So like in hyper technicalities, once again, the damage was already proved because they showed that even confirming something indicates that the damage was there. But secondly, that's not even relevant to the point of the legislation at hand. You must remember, going back to the intent of the legislation, that almost any leak within itself damages cohesion. A leak is almost inherently, if it goes to more than one person, going to travel. It's not relevant to prove it within the direct context of the trial, only that it occurred more than once, because the legislation and law at hand confirms that. And then on top of that, the defense spent the entire trial basically victimizing themselves. The very act that they believe that they know this was wrong confirms that, and they're simply attempting to push the blame onto me. They're attempting to push the blame onto others, whereas the blame for the illegal act lies on them. Lastly, I would just like to make it clear, this is a public issue. Not only does it deal, and we heard testimony.
You gotta stop. You're done.
Thank you. The plaintiff rests.
Okay. Sarah or Maddie, would either of you like to use your time?
I would.
All right, Madison, you've got 3 minutes and 52 seconds. Let me go ahead and line that up. 3 minutes 52. Whenever you're ready.
So essentially, I just want to know where this legal standing of damage is coming from. Damage is kind of relative, and it's not legally defined in our bylaws or the CCR Constitution. Also, I don't think that it affected any kind of board cohesion, because at the time of my firing, which I was never notified of, but I assume it was sometime in September, the board was already not the most cohesive and hasn't been for a while. So I don't think this screenshot affected any of that. And as far as I'm concerned, I'm sure that Sarah has maintained a professional relationship in the CCR board chat. And as far as victimization, we are victims. We're victims of a political attack, and this case being used as a political tool. Thank you.
Okay, and Sarah, you've got 4 minutes and 20 seconds. Would you like to use any of it?
No.
Okay. Given that all parties have made their comments, we're going to go ahead and close the hearing now. I will go ahead and issue an opinion in this case. I can promise you guys, let's see, what's today's date? It's the 18th. I think there isn't any, let's see, decisions shall be announced. Public, if the decision is pertinent to voting delegates. Yeah, so there isn't any explicit time frame as for when I have to issue an opinion. I can promise it to you guys by the end of the week. So let's call that December 23rd. That's Sunday. I will have that opinion to you guys out no later than 5 p.m. on the 23rd. Thank you guys for coming. I'm glad we were able to get this figured out. Thank you guys for keeping things civil, and I will go ahead and email everybody involved by December 23rd at 5 p.m. no later. In that case, what's that?
Thank you, Your Honor. Thank you.
The trial
Madison, what was that?
minutes. Will we receive any minutes that the clerk took?
Yeah, so Kevin took minutes. I'll get those to you ASAP. As soon as Kevin is finished, I'll look them over, just make sure there aren't any typos. And as soon as possible, within the next, day or so, I'd say those will be out to you.
All right, thank you.
Thanks, guys. Anything else? Okay. Have a great rest of your day, guys. Good luck with finals.